Hi, class. Welcome back. This is Professor Watson. This is chapter one. We are looking at LGLA 2303, right? Personal injury and torts law. This is the second half of chapter one, so I hope you found the right place. I think I started just a second ago. Let me share that with you on the screen. If you look at our eCampus shell, you should see my class notes, right? These are the same notes that I lecture from, and so I want to provide them to you. If you have seen them before, you are welcome to print them out. You are welcome to use them, and you can follow along. They should follow your chapter as well. You'll see this is the stuff we talked about in the last recording, right? We talked about what is a tort. We talked about some basic definitions like tortfeasor and plaintiff. We talked about the difference between a crime and a tort. We talked about the sources of tort law and the public policy behind the law of torts. And now to pick up the second half of the chapter, let's start talking about the categories of torts. If you haven't pulled those class notes up yet, I encourage you to look at them, and I hope they help you. And if they don't help you, then don't look at them again. If they do help you, feel free to follow along, print those out, use them for your own notes. You can take notes in the margins if you like to. All right, so picking up with the second half of chapter one, categories. There are multiple different kinds of torts. Basically, there's three main categories. The first category, the one that by far and away exceeds all the others, is negligence. Okay, negligence actions. There are more negligence actions filed in courts across the United States than there are any other kind of tort. All right, negligence actions involve accidents. Right, they involve breaches of duty. They involve taking unreasonable risks that cause harm to another person. All right. Tort law requires negligence law. Negligence is a tort. Negligence law and tort law requires defendants to use reasonable care. Okay, you're going to hear that a lot until you are sick to death of it. Reasonable care. Tort law requires individuals to use reasonable care to avoid causing injury to another person, to avoid causing foreseeable injury to another person. Okay, we'll talk about all the specifics and the elements of negligence coming up. In fact, we'll do it before the end of this chapter, and then we'll talk about each one of those elements of negligence in great detail. I think we have a one chapter apiece for each element. All right, but negligence involves, again, it involves tort law imposes a duty on everyone to use reasonable care when they choose to do something. And if they fail to use reasonable care, and if that causes injury to someone when it was foreseeable, then the negligence law recognizes that person who is injured, that victim, can sue the tortfeasor for damages. All right. A car wreck is an example of negligence, unless you're ending somebody on purpose, right? If you accidentally run a red light, you had a duty to use reasonable care when you were driving your car. Running a red light, not reasonable care. And as a result, if you injure someone, you'll have to pay their damages. All right. There's lots of other negligence cases as well, though. We see things all the time, like everybody knows about medical malpractice, right? I had to have surgery, and the doctor left a clamp inside of me, and as a result, I was injured. I had to have another surgery and take the clamp out. Maybe it caused other health problems, and so I'm going to sue that doctor for medical malpractice. Everybody knows those fancy words, medical malpractice. Medical malpractice, really just another negligence case. It's a fancy negligence case. It has extra rules and extra statutes that govern it, but medical malpractice, just a negligence case. It involves the doctor's duty to use reasonable care. And if you sew somebody up and leave a clamp inside, you've breached your duty of reasonable care, and so you have to pay damages. All right? That's negligence. We'll talk about negligence first this semester. We'll spend a long time on negligence because, again, negligence, there's so many lawsuits based on negligence. Okay. Second type of tort is something called an intentional tort. All right. If negligence are those accidental torts, intentional torts, those are the ones you did on purpose. All right. Intentional torts are based on actions that were not an accident at all. They were intended to cause injury. Okay. we talked a little bit about in the last recording that sometimes there can be some overlap between tort law and criminal law. And that's where we usually get into intentional torts, right? If I accidentally run into you with my car, that's negligence. But if I intend to punch you in the face, or I intend to run into you with my car, that's not negligence anymore. That doesn't involve breaching a duty of reasonable care. That involves you did something on purpose, okay? Intentional torts, generally defined by common law, just like negligence is generally defined by common law. And intentional torts can also be a source of tort liability. We will learn many chapters from now that the big thing about intentional torts is that not only can you sue to make the plaintiff whole, intentional torts are that one area where you can sue for additional damages, where you can sue for punitive damages, where you can sue to punish the defendant, make them pay extra to deter them from doing it in the future, to deter other people like them from engaging in the same kind of conduct in the future. Okay, so those are intentional torts. We'll talk about that in several chapters. Okay. The third type of tort are what we would call strict liability offenses. Okay, strict liability cases. In strict liability cases, fault or intent even is not an issue. There are some cases where it doesn't matter if you intended to cause the injury. It doesn't matter if you breached a duty of care. There are some areas where the law says, you know what? If you're going to engage in this type of conduct, it doesn't matter whether you meant the injury. It doesn't matter whether you were as careful as you could possibly be. If you choose to engage in this type of conduct, if you cause damage to somebody, then you're just going to be liable, right? You're strict liability. All right, that's the third type. We see that in things like, hey, if you're a father, an NFL player, and you decide to keep a leopard in your own house, dangerous animal, right? Strict liability. If you keep a leopard in your house, it doesn't matter how careful you are about keeping that leopard. If that leopard gets out and it mauls some child or some old lady walking down the street, doesn't matter how careful you were, you're going to be strictly liable. Okay. Explosives, unusually dangerous activities like using or even maintaining explosives. You keep explosives in your back in a shack in your backyard, and they go off and they blow up the neighborhood. Doesn't matter how careful you were. Doesn't matter if you breached the duty of reasonable care. Doesn't matter if you intended it. You're going to be liable under strict liability. Okay, so 3 types of torts: negligence, intentional torts, and strict liability. Negligence, those cases where it was an accident, you breached a duty of care. Intentional torts, those things you did on purpose. And then strict liability, those cases where it doesn't matter. It doesn't matter if you were careful, doesn't matter if you did it on purpose or not. If you did it, you're going to be liable for the damages. All right, we'll talk about all of those this semester. But the granddaddy of them all is negligence. Okay, we're going to get into negligence in the next couple of chapters. So let's set that up now. Let's start talking about negligence. All right, what is negligence? Negligence, again, is basically when you violate, when you breach a standard of care, when you harm somebody because you did something that wasn't reasonable, right? That's kind of what it comes down to. When you harm somebody because you did something that wasn't reasonable. That's not necessarily a specific definition, is it? Who's going to decide whether your conduct was reasonable? Well, that generally comes down to the courts. And the courts may be a jury if the party selects a jury, or it may just be the judge. But the courts, if you bring a suit for negligence, it's the courts that are going to decide whether somebody breached their duty of reasonable care, whether somebody should be made to pay for the injuries that they allegedly caused to you. Now, they don't get to just decide that willy-nilly, right? This is a country of laws, and they have to be guided by our legal principles, all right? And in this situation, negligence almost exclusively covered by common law, all right? And common law over the years has developed to identify 4 or 5, depending on exactly how you count them and categorize them, but it's always the same 4 or 5 elements of negligence, all right? They are duty, breach of duty, causation, proximate cause, you can call that 4, or you can include that in causation, and then damages, all right? Duty, breach of duty, cause, proximate cause, and damages. We're going to talk about each of those 4 or 5 elements, however you want to count them, this semester. Each one of them will give its own chapter. That's how important they are, okay? We'll spend a lot of time discussing each of these elements, but I guarantee you for almost every single class, we're going to start it with understanding the elements of negligence: duty, breach of duty, causation, including proximate cause, and damages, all right? The law is systematic. You have to know what the elements are. You have to know what the common law is. If you bring a case for negligence, you have to prove duty, breach of duty, causation, proximate cause, and damages. If you fail to prove even one of those things, you lose your case. All right. So duty, breach of duty, causation, proximate cause, and damages. Learn it, live it, love it, memorize it. Because remember, in every single negligence case, you're going to have to prove all 5 of those elements. Or if you're the defendant in every single negligence case, if you can beat even one of those elements, then as a defendant, you'll get off. Okay. So understanding those elements is an important, necessary part of negligence law. One or two things we'll mention before we finish up here in chapter 1. A couple other things that go along with negligence. Now, we're going to talk about duty, breach of duty, causation, proximate cause, and negligence in the coming chapters as we go. All right. But in general, we'll find out when we start talking about duty that the law imposes a duty to take reasonable care when you choose to act, when you choose to engage in any kind of conduct. The law imposes on you a duty to use reasonable care not to injure other people. But it requires reasonable care, okay? As a result, sometimes someone chooses to act and their actions cause injury to someone else. But a jury or a judge could decide that, well, even though they caused injury to somebody else, they still were using reasonable care, right? It was just an accident. Or in this case, your book mentions an unavoidable accident, okay? An unavoidable accident. An unavoidable accident is something where somebody may have chosen to act, and so they had a duty, but a judge or jury has decided that either they didn't breach that duty, or the breach of that duty wasn't really the cause. It wasn't the proximate cause of the injury to the other person. Okay, an unavoidable accident then is not negligence because there's no causation, right? It wasn't my negligence. It wasn't my breach of duty that caused your injury. I was following my duty. I was being as reasonable as I could, and you got injured anyway. So it's no more my fault than yours. Therefore, you're not going to win. Okay. So an unavoidable accident is a defense to negligence. If you can prove something that was an unavoidable accident, then it's not negligence because it wasn't proximately caused by the defendant's breach of their duty. All right. And again, we'll talk about all this in a couple of chapters. But I guess we can go ahead and we can define proximate cause right now. Causation is something that without which something else wouldn't happen, right? Causation, if I push this computer over, it's going to fall back. I caused the computer to shake and make you all sick. If I drive my car and I run the red light, that causes the damage to your car when I run into you, right? But proximate cause is a little bit different. There's cause and fact. Did I actually cause it? And then there's proximate cause. Proximate meaning proximity, right? Nearness, meaning is the cause closely enough related that we can say, yes, this person should be responsible. Okay. So proximate cause, we get a lot of big, long legal definitions, but proximate cause is often defined as an uninterrupted sequence which causes an injury and without which the injury would not have happened. Okay. So if a person is driving recklessly and they have an accident, then the driver's recklessness caused the accident, right? But if a person is driving normally and they suddenly have a heart attack and pass out and they run into somebody at the intersection, um, the driver's actions may not be the proximate cause, right? The driver didn't breach any duty. They were driving carefully. It was the heart attack. Or if they were driving along and suddenly the wheel fell off of their car, right? If they had no reason to believe that the wheel would fall off, then it's the wheel falling off of the car that's the proximate cause of the injury, not the driving. And if I didn't cause the wheel to fall off, then that's not my fault. Or if I'm driving down the road, I'm driving 10 miles an hour under the speed limit. I'm being as careful as I can be, and a child runs out in the road, and I swerve to miss that child, and I hit your car. That may be an unavoidable accident because my driving wasn't the proximate cause. The child running out into the street was the proximate cause. Okay. Um, have you heard of the butterfly effect? Some people talk about the butterfly effect, right? If a butterfly flaps its wings in Tokyo, you can string together enough facts to show how that butterfly flapping its wings in Tokyo eventually led to a hurricane hitting Florida. Maybe that butterfly flapping its wings, you may be able to stitch those things back to the hurricane in Florida. You may be able to stitch those causation back to the butterfly flapping its wings, but it doesn't mean that the butterfly flapping its wings was the proximate cause, right? It wasn't close enough that we could have expected by flapping my wings I was going to cause a hurricane in Florida, right? Nor could we know that, by driving my car carefully, I was going to have a heart attack. Or by driving my car carefully, a child was going to run out in front of me. Okay, so unavoidable accident. Generally, we think of that as a defense. If the defendant can show that the accident wasn't avoidable, then what they're saying is it wasn't my breach of my duty that caused your injury. It was something else. All right, so unavoidable accident, something to always remember when we're talking about negligence. Last term that your book wants to talk about before we get into negligence in the next chapter is gross negligence. All right. Negligence, we will learn in the coming chapters, is when someone breaches their duty of reasonable care, and that breach of duty causes injury to someone. Okay. In that circumstance, if your breach of the standard of care causes injury to someone else, and they can sue you for the damages to be made whole. All right. But sometimes we got fools, right? There are fools in this world. And sometimes we have people that don't just breach their duty of care. They go so far beyond that maybe maybe the injuries they caused weren't intentional, but they go beyond negligence. Okay. So gross negligence is generally conduct that constitutes more than just mere negligence. Gross negligence involves acting with so little care, right, as to show a complete indifference to the safety of others, or to act with such conscious disregard. We often see that term, conscious disregard. You were conscious of a risk, you knew there was a risk, and you disregarded it. You did it anyway, of a high risk of care to others. Okay, so there's negligence. That's when you have an accident. But gross negligence is when you're extremely reckless, right? Or you consciously ignore a high risk of danger to somebody else, and you just do it anyway. And then when you cause injury to somebody else, you may act like, oh well, sorry, right? Except in that point, we go beyond negligence and we go to gross negligence. Why do we care? Why do we have a different definition for negligence and gross negligence? Well, we'll get to that later in the book. But gross negligence in many states, gross negligence, like intentional torts, would permit a plaintiff to recover punitive damages. Okay, so if you accidentally run a red light and hit me with your car, you can sue me for your injuries and you can be made whole. If you're doing 120 miles an hour in a school zone when you run the red light and hit my car, that goes beyond simply breaching your duty to use reasonable care when driving, right? Doing 120 in a school zone, that goes to conscious disregard. Everybody knows if you do 120 through a school zone, you're at least creating a high risk of danger to somebody else, right? A high likelihood of serious harm. And if you ignore that and do it anyway, well, that may rise to the level of gross negligence. You want to know what the exact definition of gross negligence is? Well, you need to know what jurisdiction you're in, and then you need to look up your common law. Okay. Negligence, gross negligence, unavoidable accidents, tort law. That's what we're talking about this semester. We're going to talk about these private wrongs where one person or one entity can sue another person or entity for these private wrongs. Again, we're going to talk about negligence first, and next week in the next chapter, we're going to start getting into those first elements of negligence: duty, breach of duty, causation, proximate cause, and damages. Right? We'll start with duty in the next chapter. After we finish negligence, then we'll move on to talk about those intentional torts. And finally, things like strict liability. And if we get to it, we'll even cover some things like workers' comp and those kind of things. All right. So that's negligence. Read the chapter, look at the class notes, or look at my lecture notes. Then you've got a couple of assignments this week. If you have any questions at all, give me a call, shoot me an email, come to class and ask. Otherwise, I'll see you next chapter. Thanks so much.